out that Senator Brandis did not, as he told the Australian Senate back on the 4th of May, consult with the Solicitor General about the change that he has made to the law relating to the Solicitor General's provision of advice to the Commonwealth. It is beyond doubt, as the Solicitor General himself has made clear over the course of extended evidence this morning, that he was not consulted about the making of this new law, and he was not consulted about the substance of this new law, which of course impose a written consent requirement. From the making of this law on the 4th of May, anyone in the Commonwealth, from the Governor-General through to the Prime Minister, through to Secretaries of Departments and Senior Ministers, have to get the written consent of Senator George Brandis before they can seek the advice of the Solicitor General. As we've heard also today, the making of this new law and the imposing of this written consent requirement have beyond doubt compromised the independence of the Solicitor General. They have destroyed the integrity of his office. He has given detailed evidence about how his performance of his duties as the prime legal advisor or the second law officer of the Commonwealth have been compromised by this change that has taken place. I say again that Senator Brandis has misled the Australian Parliament, and on his own words, it is a serious offence, and the penalty for this offence is for him to resign. Mr Turnbull has said in the past on numerous occasions that it is a serious offence to mislead the Australian Parliament, and that the clear penalty for that offence is to resign from the Parliament, and if the Minister won't resign, that he be sacked by the Prime Minister. Well, now Mr Turnbull is in a position to do something about the words that he spoke when he was in opposition, and that is to take action, because it's clear now that Senator George Brandis won't resign. It's for Mr Turnbull to sack him and give effect to his own words as to the appropriate penalty for this serious offence. And there's one other matter that I'd want to raise before I take your questions, and that is the extraordinary, disrespectful, discourteous, rude conduct by two government senators who were asking questions of the Solicitor General in this Senate hearing this morning. This is not the behaviour to demonstrate in the Australian Senate towards senior statutory office holders. I've given up hope that Senator George Brandis would ever look after or make sure that respect is given to senior statutory office holders. We've seen, of course, that he himself attacked the President of the Human Rights Commission, Gillian Triggs. He's in effect been attacking the Solicitor General, so I'm not even going to bother calling on Senator Brandis to discipline these government senators and to disown the way in which they behave today, although he should. What I'm doing is calling on Mr Turnbull to step in and make it clear that he does not countenance this kind of attack on the Solicitor General of the Commonwealth, the second law officer, the primary legal advisor to the Commonwealth. These two Liberal senators should be ashamed of themselves, and those of you who watched this proceeding this morning would know just how disgracefully and disrespectfully they behaved. Do you have any questions?
The government's unimpressed that you contacted the Solicitor General during the election period. What did you discuss with the Solicitor General? And was that a wise thing to do, given that now it seems like he's in a bit of trouble over this?
Indeed, it was an absolutely appropriate thing to do. I did contact the Solicitor General during the election campaign when it came to my attention that this extraordinary change in the way in which the Solicitor General does his work had been tabled in the Australian Senate by Senator Brandis just before the Parliament was dissolved for the election. It's absolutely appropriate for me as the Shadow Attorney General to contact the Solicitor General to discuss with him two very simple things, which was, were you consulted? To which he told me no. And do you approve of the making of this direction? Do you think it's the right thing to do? To which he also said no. There can be absolutely no suggestion, and we've got, again, the smoke screen and obfuscation and slithering around by Senator Brandis trying to distract attention from the offence that he's committed, suggesting that there could be anything wrong with the Shadow Attorney General speaking to the Solicitor General of the Commonwealth about a major change to the way in which the Solicitor General does his job. So, yes, of course I spoke to the Solicitor General. It was absolutely the right thing to do. It's a complete nonsense, and it's usually the case when Senator Brandis opens his mouth that he's speaking complete nonsense. It is a complete nonsense to suggest that this is in any way a breach of the so-called caretaker conventions. The caretaker conventions are there to restrict the ability of the government to make major decisions during the period between the dissolving of Parliament and the election, and they've been in place since the early 1950s. Very destructive Attorney General, Senator George Brandis. Of course, it is a matter of concern. It goes directly to the rule of law in Australia.
Based on the Solicitor General's evidence, do you think that the Attorney General was trying to cut people like the Prime Minister out of the conversation on this kind of legal advice?
It's obvious that that's exactly what the Attorney General was trying to do. He was putting himself between the Governor-General and the Solicitor General. He was putting himself between the Prime Minister and the Solicitor General. He was putting himself between every Secretary of a Commonwealth Department and every head of agency of a Commonwealth agency by requiring that his written consent be obtained before the Solicitor General does what is his statutory duty, which is to act as counsel for every arm of the Commonwealth. I find it extraordinary that he's done this. He hasn't put forward the slightest justification for it. He's tried to cover up what he's done with a whole lot of mumbo-jumbo and nonsense. He's tried to distract attention from the direct lie that he told the Australian Senate in a document that he tabled in the Senate on May the 4th this year.
Do you still maintain that William Shockley answered the things the Attorney General was doing is still wrong?
My complaint against the Attorney General is that he was sidelining the Solicitor General, and I've been asked about this since the Attorney General since George Brandis raised this yesterday in Senate question time. My concern, if you read the whole of the text that he quoted half a line from, is not the seeking of a second or a third opinion once the Solicitor General has given an opinion. It's the complete sidelining of the Solicitor General altogether by going to somebody else. As I said in the book, as quoted by Professor Appleby, the Solicitor General is the first source of advice on important legal matters for the Commonwealth. His advice carries more weight, I said in her book, or she quoted me as saying in her book, his advice carries more weight than that of the Australian Government Solicitor. His advice carries more weight than that of the private bar, and that's why I went on to say, and she quotes me as saying, you might need 2 or even 3 other opinions, but minds can differ on really difficult legal questions. No, my complaint, and George Brandis shouldn't be allowed to get away from this, is the sidelining of the Solicitor General, which is what he has done. It is what the Solicitor General said in a letter to him that has now been tabled in the Senate he had done in relation to, of all things, the plebiscite bill that is now in the Parliament. And who knows which other matters the Solicitor General's advice was sidelined on, where this Senator George Brandis has gone off and got advice from somebody else because he was worried about what Justin Gleeson, one of the most eminent legal minds in Australia, might actually say on a particular question. It is no way for the Attorney General to treat the Solicitor General. And while I'm on it, what's also emerged in these Senate hearings, what's also emerged from that letter that I just mentioned of the 12th of November, is that George Brandis has misled Australia and misled the Parliament about even the effect of advice that the Solicitor General did give. There is not one example here of misleading the Parliament. There are multiple examples of misleading the Parliament. George Brandis has not provided the slightest explanation. He's tried to split hairs and argue that consult doesn't really mean consult. Well, I think Australians know what consult means. It means that you have to tell the person you say you're consulting with about the thing you're about to do. And that's the thing that George Brandis did not do.
That is the Shadow Attorney General Mark Dreyfus there speaking in relation to the Senate inquiry that is being held today, where the Solicitor General and the Attorney General appeared. Mr Dreyfus has confirmed that beyond doubt, in his words, Senator Brandis should resign, and if he does not resign, Mr Turnbull should sack him. Mr Dreyfus went on to say that it was beyond doubt that Senator Brandis did not consult with the Solicitor General about the changes to law, where those seeking advice from the Solicitor General needed to go through the Attorney General's department. Department first. Mr Dreyfus said it was beyond doubt that the Solicitor General had made clear over a course of evidence that he was not consulted about the making of the new law or substance of the new law. It's important to note that Senator Brandis in the Senate inquiry defended his actions, and he says that the dispute between him and Mr Gleeson centres on the meaning of consultation. He believes he did consult Mr Gleeson, and he denies misleading the Parliament.